submission from Natasha Hamilton-Hart, who is joining us via Zoom.
Thank you very much. My name is Natasha Hamilton-Hart and I'm a professor at a New Zealand university. And my thinking on this issue is informed by my academic work in comparative political economy and political institutions, but I make these remarks in my personal capacity. So I want to speak to three issues raised in my written submission. And in brief, they are: one, that the principles of the Treaty of Waitangi, as they currently figure in law and public governance, lack democratic legitimacy. And two, that the Treaty of Waitangi should not be mined to generate constitutional principles. And three, that the bill's proposed principles 1 and 3 capture fundamental democratic values that we should protect somehow. So first, where we stand now lacks democratic legitimacy. I think a constitutional revolution has taken place since the 1980s, and many of our foremost treaty scholars would acknowledge that. The insertion of treaty principles references in legislation has paved the way for the courts and the Waitangi Tribunal to generate law that runs ahead of clear parliamentary intent. And this process continues. The guidance disseminated by the Waitangi Tribunal explicitly says that the principles will continue to evolve, but apparently without any parliamentary input into what they are. And this is the blank check that is handed to the most unaccountable and least democratic institutions of state. I would like to remind the members of this committee that the prime architect of this constitutional revolution back in the 1980s, Geoffrey Palmer, intended the legislative references to the treaty principles to be such a blank check precisely in order to bring about changes that he did not think Parliament would consent to. And I will just briefly quote from his 1992 book, where he says, "Legislation was used to set up processes and procedures and the principles on which decisions should be based. The initial commitment required was to a process. No tangible outcome was provided by the legislation itself. What should be done was to be decided only after judicial or quasi-judicial processes had assessed individual cases. First, it was necessary to give the courts something to interpret." And that is what he did. Now, this is no way, I think, to do constitutional change in a democracy. If you celebrate the current status of the treaty principles as created by the courts and the Waitangi Tribunal, then I would ask you to have the courage to ask voters for their consent. Secondly, in my view, the treaty should not be mined for present-day political purposes. And here I disagree with the authors of this bill. The treaty is important to New Zealand's history, but it is a document of its time. And there was a time that ushered in a period of intensive colonial rule around the world. It was a racist time when it was commonplace to ascribe personal characteristics to whole groups of people based on their ancestry. It was a time when the nascent colonial state didn't really run a tax system, let alone take nearly a third of national product in tax, when the state itself did very little beyond attempts to secure order and property rights. And it was very obviously a time when the state made no pretense of being a democracy. So what I draw from this is that the treaty does not provide us with constitutional principles for running a multicultural democracy, which is one where ancestral lines of many families are richly intermingled, and the state runs, as I think it should, ambitious programs to promote public health, welfare, and education. Thirdly, the principles 1 and 3 of the bill have great merit in reminding us of the importance of parliamentary sovereignty and the bedrock principle of legal equality among citizens. And this is consistent in spirit with Article 1 of the Universal Declaration of Human Rights, which begins, "All human beings are born free and equal in dignity and rights." And this is a good principle. I think it captures the spirit of shared humanity that has sustained our most progressive achievements as a nation. And I would include in that the construction of the welfare state under the leadership of Michael Joseph Savage. So many opponents of this bill say that we have an urgent moral duty to reduce poverty and other inequities. And they note that Maori people are disproportionately represented in almost all areas of disadvantage. The playing field is not level. And I agree. But my question is, what does it take to generate the political will and capacity to make the investments to address these injustices? Now, my academic work for the past 3 decades has been on political institutions in post-colonial societies. And one very clear takeaway from this work is that countries with inclusive political institutions do a far better job of generating the solidarity necessary for shared prosperity. The so-called consociational democracies, where race or religion shape the terms of political engagement, produce profoundly inferior outcomes. Now, several submitters today have said equality does not work. However, when it comes to core legal rights, political and civil rights, I think they are mistaken. I think inequality is what does not work. So if we base our constitutional framework on the idea that we are separate peoples transacting according to contract, we diminish our sense of shared nationhood. I think a nation, as put forward famously by one of my former professors, Benedict Anderson, a nation is an imagined community in which, whatever our differences, we are one people. Now, today we have heard many submitters making the case that we are not, that Maori are a distinct people with claims not just to cultural autonomy, but political nationhood, sovereignty, tino rangatiratanga, self-determination. Now, that is an aspiration shared by many colonized peoples, and the treaty principles as they have evolved over the past 40 years represent an attempt to placate this aspiration. I don't think they ever will, because sovereignty cannot in a practical sense be shared, and especially not sovereignty in a modern, democratic welfare state. We have work to do in this country to make the investments needed for inclusive flourishing, and I believe we can best do this work on the basis of equal citizenship, not division by ancestry. Obviously, many in this room and outside believe differently, and maybe a democratic majority will be persuaded that those who want to embed the treaty and its two peoples approach to citizenship as superior law, maybe they will be persuaded, but maybe not. And I think it would be reckless to gamble on this issue going away. And I want to make a final point is that we rely on the law as a core institution that enables civil, fair, and prosperous society. But all law is anchored in and depends on a political order. And the political order and the political authority is not acquired through law. It makes law possible. And to be sustainable, law needs to be politically legitimate. And it is your job as parliamentarians, you are the public's representatives entrusted with making law, to foster a civil and inclusive discussion of what our constitutional order should look like. Thank you.
Thank you, Natasha. We've got a couple of minutes for questions in order from Joseph, Takata, then Todd.
Good morning, Natasha. Just in your study of these colonial states, did you see any others that extended the rights of the Magna Carta to the Aboriginal peoples at the time of their founding, particularly the principle that the king and his government were not above the law?
So there are references in a lot of treaties that the British and the Dutch signed across Asia to having the rights of subjects. Right, this is this is not an era of democracy, and I haven't come across any explicit mention of the Magna Carta. They do very explicitly in that period of time envisage a system of indirect rule. That is how the British and the Dutch ruled their colonial territories. So they struck agreements with local rulers who at the beginning of the colonial period, they did envision as governing their people. The British state didn't want to get involved, right? They just wanted to extract colonial wealth. But this actually proved completely unworkable over the next centuries.
Thank you, Natasha. We'll probably take a final question from Takata Ferris.
Kia ora, Natasha. Hey, you mentioned like the country not being able to thrive due to division by ancestry. I'm just, is that something that you think the treaty promotes, division by ancestry?
I think it does. Not intentionally. I don't think anyone wants that. But I think it is the inevitable result of trying to carve up sovereignty and allow for meaningful tino rangatiratanga.
Thanks, Natasha. Look, we'll probably end this session there. I just wanted to acknowledge your submission and thank you for joining us this morning.